I'll do shared screen. There we are. All right, so we're doing Module 9 Confidentiality, and we're looking at problems 33 to 35. We've got Brendan there as well. Hi, Brendan. Just write down. You're attending, that's good. Okay, so that's what we're doing. So I'll just stop share and go to the actual problems, I think. The best way would be to actually have a look at the answer guide. I put up an answer guide on the tutorial website there today. So, give me a second and we'll get this problem. It's a bit disappointing. No one had a go at, well, I think one person had a go at problem 34, which wasn't that bad. It just required a little bit of reading of some case law, that's all. But anyway, let's have a look at problem 33. So this is really about search warrants and legal professional privilege. So just to run through what happened, basically the tax office is using the federal police based on information from the Customs Service to carry out raids on the offices of a barrister and also the New South Wales Bar Association. So there's 2 points that they're raiding. Now, the tax officer had proper documentation for their raid on the Bar Association, and you've got the respective provisions of the Income Tax Assessment Act there. And the police executed their warrant under Section 10 of the Crimes Act 1914, and that's New South Wales as well. And there were, well, it's a federal. There were 2 teams of 4 that went into the premises. Jill Booth, who was in charge of the raids, has discussed the problem with the Bar Association essentially the week beforehand, but not with David Garfunkel, who's the barrister. So he didn't have any warning whatsoever. All right, so what the ATO is looking for is essentially money made from the sale of the drug ecstasy. There's no criminal charges have been laid before the raid, so they're basically conducting the raid to get enough evidence to lay criminal charges. And they think that Jim Sly is importing and exporting, well, he has this import-export of artefacts business, but he's bringing in the drugs, they're alleging anyway, using freight containers. Okay, he hasn't been caught with the drug. There is some, despite that, there's some evidence he's involved with it. In the last 2 years, he's opened up, 4 new shops. He's got all of this property, unexplained wealth, essentially. Jim has his lawyer, David Garfunkel, that's the barrister, and David has admitted to the bar 10 years ago. He's practiced as a barrister a few years before going to study in India, and since his return 4 years ago, he has served as legal advisors to this movement of people who have these businesses that they think the drugs are coming in through. So he set up all these corporations to deal with the business interests, and there's a number of the members of this religious group who he does work for and invested in various businesses. One of the companies has gone bankrupt. Several of his clients have also invested in that, then complained to the Bar Association that the barrister David's negligently advised them. The association also has on its files its problems with the ATO. So the Bar Association files have got all sorts of stuff on him, basically. And I also suggest he's got too many assets in the light of his income. There's also allegations from former clients that he's actually been involved in drug trafficking. And that information has been collected by Alison Parkinson, who's employed by the Bar Association. And that was all collected in relation to the association's complaints committee, because they're receiving all these complaints. All right, she was admitted as a solicitor last year, but does not have a current practice certificate. In the light of this information, the Bar Association Complaints Committee has had a member interview with David, so they've interviewed him. And he has a barrister representing him concerning all these matters. He's been cooperative, but he refuses to give any further information concerning drugs. So there's not a lot they can really do about the drugs side of it. If they don't have sufficient proof in relation to that, that won't really progress anywhere with the Bar Association. So they're really going to see what the outcome of the police investigation is. Jill Booth's officers, so that's the ATO or police who were that side of it anyway, the person who's running that, surprised Alice when they arrive at the doorstep of the Bar Association, and she surrenders the file on David Garfunkel, and it includes all this other information on Jim Sly as well. At David's office, from which his companies also carried out the business, police officers were confronted by an employee solicitor who'd been practicing only 2 months. So in the raid on the barristers' chambers, there's a really junior solicitor who'd been hired by David to do some filing and a little bit of research, but doesn't have any significant experience. And it's taken place at 5:30 on a Friday, and they only took documents that they were authorised to take under the warrant, but David thinks some of them are privileged. Okay. So, as a result of the raids, Jim Sly and David, the barrister, have been charged in the federal court with conspiracy to import and sell a prohibited drug. And during the trial, both are objecting to the use of documents taken during the raid, and their basis of their objection is that they claim these documents are privileged, and therefore they can't be used in the proceedings. Okay, so I suppose the first question I just asked generally at this point is, what's the public policy in relation to having legal professional privilege? What's the policy consideration that has allowed that to arise? What's the idea of it? Any suggestions? This is where everybody goes silent. Dear. Come on, Lauren. I know you can answer this one.
Privilege is for the client.
Oh, okay, sorry. Was that you, Brendan?
Yeah, that's me.
Okay, so the privilege is for the client, that's true, but why is the client getting this privilege? Why should they be entitled to to hide documents in effect from the court so it doesn't go into the proceedings? What's the idea behind it? It's the same sort of idea as why solicitors have, keep things confidential. No? Anybody help you, Matt?
I'll have a go, Stephen. So that you can represent the client with all the information that the client is able to talk honestly and candidly to you without fear of reprisal from a confession or a disclosure.
That's right. So that's the public policy, or one public policy ground for it. What's another public policy that runs totally against that? That's the exact opposite. What's the court trying to do? What was the court actually trying to do? They're there to resolve, in this case, a criminal prosecution, aren't they? So wouldn't you think public policy would suggest that they should be given all the evidence, they should have available to them all the evidence that's possible so that they can actually make a decision? See, that's the other public policy argument, is that the court should have full information to make appropriate decisions. So you've actually got two competing public policies dealing with this issue of legal professional privilege. Which of those ones dominates?
Confidentiality.
That's right. Confidentiality does dominate. There are exceptions. Does anybody know what the exceptions are?
If the client discloses that they're going to do a future crime.
Is it a future crime or a past crime?
A future crime.
What's another one? Waiver. You come across waiver? That's where you waive your rights to the privilege. Any idea?
If it's by statute as well, if the statute implicitly allows for the... the privilege, or doesn't, allows for the privilege to be waived or whatever,
Yeah,
or to ignore the privilege.
that's right. So they're the three main exceptions to it. So it's not a total policy that you can never never breach legal professional privilege, but it's still a dominant. It's certainly dominant over the rights or the public policy and courts being able to make decisions based on all the information. So let's have a let's have a look at what's happening here. So if we skip down here, excuse me, if we look at the Bar Association rules, there's a couple of them there, isn't there, in relation to confidentiality and conflicts. Okay, so the main one is, 108 and 109. So you can see there in 108, a barrister must not disclose except as compelled by law. So that except as compelled by law is recognising that you can have statutory provisions which require or compel these types, disclosures. Or use in any way confidential information obtained by the barrister in the course of their practice concerning any person to whom the barrister owes a duty or obligation to keep such information confidential. And then it has some exceptions. If the information is later obtained by the barrister from another person who's not bound by the confidentiality. So that's in effect saying that the information is not confidential because it's out there. And the second one is the person has consented to disclosing the information. That's the waiver exception, and that's in 108B. And then in 109, a barrister must not disclose except as compelled by law or use confidential information under 108B in any way other than as permitted by the specific terms of the person's consent. So you have to be very strict in terms of complying with the waiver. Okay, so all right, so you can see there, I won't go through it. Why don't you tell me what you think the answer to the question is, then we'll go through it. What do you think's the situation in relation to, say, the Barristers Association, the Bar Association? What do you think the situation is there in terms of the answer? Do you think that's subject to legal professional privilege? What do you think?
In my notes, I thought no, the Bar Association would not be under that confidentiality clause.
Yes, that's right. They're not actually subject to it, because those provisions in the Income Tax Assessment Act actually require the disclosure of that information. What about the position of the barrister, where they've raided the barrister's office and you've got the junior solicitor giving up the files? What do you think about that?
Shouldn't they have given them warning before they raided so they could protect the files with privilege of their clients?
Yeah, that's right. I mean, you can see that there's similar provisions here in the solicitors' rules about not disclosing information. So if we just skip down here a little bit, essentially they should have given notice to that to the barrister's chamber so that they could get the documents prepared. See, there's that argument about the future crime. See there, you can rely on Australian Federal Police and ProPen in arguing that any privileged documents relating to the commission of future crimes would not be protected. So future crimes, you're right, past crimes essentially may not be protected under these rules. So you're right about future crimes. I think you're right. I think the barristers' premises ones would be privileged, but the Bar Association ones wouldn't. And essentially the other thing I've noted there is that the barrister declined to answer any questions related to drug allegations, which he's entitled to do. There's no obligation on you to answer those questions to either the Bar Association or to the police for that matter either. So that's essentially really what that problem is about. It's just to show you that there's a distinction between different situations with regard to legal professional privilege. We've got the Bar Association, it's not privileged, whereas in relation to the actual barrister it would be. You can see there the primary reason for that is this case of Goldberg and NG. You see, there's effectively been a waiver of the privilege because those documents have been produced to the Bar Association. So if they were relying on legal professional privilege, then they wouldn't produce them to the Bar Association either. So that's why the relevance of that Goldberg case there. All right. That's about it, I think, in relation to that question. Is there any questions about that or problems with it? If you have a look at the actual Tax Act, you can see how it works. Sorry, Luke, were you going to say something?
Yeah. Through the facts with that Goldberg case, it wasn't necessarily that, he's given the files over in relation to the tax and also for his client. But I took it that it wasn't necessarily a complaint that he was defending. Therefore, I went along the lines of it. Those documents would still be privileged.
Oh, I see. Okay. All right.
Or alternatively, that if there was documents in relation to the sale of drugs, that would be an illegal or improper purpose that he created the document. So there might be some recourse that way as well.
Well, it could be. I mean, that's actually another way of looking at it, which is right. If it's an illegal or improper purpose, then that's another exception to the legal professional privilege. So we've talked about, we raised waiver, we raised the issue of specific legislation that deals with it, but there's also this, there's a future crime situation. There's also this notion of illegal or improper purpose, which is right. So you could run that argument with this as well. So that's right for this problem. Okay, all right. Sorry, all right, well, let's move on so we get through these questions. The next one required you to have a look at SO Australia Resources Limited and the Commissioner of Taxation, which is the primary case, which is looking at the test for legal professional privilege. So the thing to get out of this is that there was a majority view of Gleeson, Gaudron and Gummo. And you can see there, just running through it quickly, that the whole issue came down as to what the appropriate test was. The test in the Evidence Act, Commonwealth Evidence Act, it was the dominant purpose test, and that was favoured by Barwick and Grant and Downs, who was in the minority view. And then you had the majority in Grant and Downs, which was Stephen, Mason and Murphy, preferring the sole purpose test. So basically what's happening is that this whole issue is being reopened, and the court is now, you can see here, the court is now asked to reconsider the balance that was struck in Grant and Downs. They go through and they explain the situation in Grant and Downs. The interesting thing about it here, about Grant and Downs, is that their honours expressed nowhere in that judgment do their honours consider the dominant purpose test as an alternative. So they didn't actually consider the other possibility. And then they were saying that the reason of the joint judgment shows that the reason which influenced the decision was a concern that in large corporations and public authorities, especially those with internal legal officers, routine reports and other documents prepared by subordinates for the information of their superiors would also, in the ordinary course, be provided to lawyers for the purposes of obtaining legal advice or assistance. It was regarded as unacceptable and contrary to the interests of justice that such documents should be privileged merely because one of their intended destinations was the desk of the lawyer. So, they then talk about the position in England and in New Zealand. where they preferred the dominant purpose test, and that the law in Australia was now out of line. Well, the law at that stage was then out of kilter with the rest of the common law jurisdictions. The parliaments of the Commonwealth and New South Wales had adopted the dominant purpose test for their Evidence Act. So in all of those circumstances, accommodation led to a conclusion that this court, this judgment, should reconsider that. So they go along the lines and they say that the sole purpose test appears to be a bright line test. So what they're saying is it seems on first glance to look perfectly acceptable. It's easy to apply. But the main objection to the test, and this came out in the New Zealand judgment, was it was extraordinarily narrow. And if taken literally, you only needed one other purpose in relation to the legal, in addition to the legal purpose, regardless of how relatively unimportant it might have been. Without the legal purpose, the document would never come into existence, and that would defeat the privilege. So they thought it was extraordinarily narrow. Then what was happening is that there were subsequent judgments who were trying to actually fit this sole purpose test to make it more like the dominant purpose test. So there was a lot of fudging going on in various decisions. And that they also said it was unduly protective of written communications within corporations and bureaucracies. And ultimately, they come down to saying that in choosing, as a practical matter, the choice presently confronting the court is between the sole purpose and dominant purpose test. The dominant purpose test should be preferred. It strikes a just balance. It suffices to rule out claims of the kind considered in Grant and Downs, and it brings the common law of Australia to conformity with other jurisdictions. Okay, so they're saying that the appropriate test is the dominant purpose test, not the sole purpose test. But what this question's asking you is, well, what about the minority views? And there were two. There was McHugh and there was Kirby. So McHugh was saying that he was unable to accept the proposition that the court should now overrule Grant and Downs. So in other words, he wanted to retain the sole purpose test. And that it wasn't appropriate to substitute the dominant purpose test. And the reason for that, there were two reasons. You can see there, he thought it would extend the area of privilege with the result that a party to litigation in the court would have less access to relevant information. That, you see, that was the other public policy purpose that I mentioned earlier, that the court needs access to relevant information, and so do the parties to a litigation to make a just decision. So extending the breadth of privilege removes documents from access by the court and other parties. And that can lead to situations where people can be jailed when there might have been information, jailed or fined, when there might have been information in documents which establishes that they're not guilty or weren't responsible and so shouldn't have incurred a fine. So you can see that McHugh's got this balance in terms of not restricting access to information. And then he says it would impose a test that is not of easy application, which seems inconsistent with the rationale of legal professional privilege. So you recall in the earlier judgments of the majority, they were saying that the original test in Grant and Downs was easy to apply, and that's what McHugh is saying here. All right, so that's basically what he's saying. So he wants to stick with the status quo. Kirby came up with basically 6 or 7 reasons, which I've set out there. I won't go through all of them, but he repeated his judgment in Propen's case, where he said that a break on the application of legal professional privilege is needed because it frustrates access to communications which would otherwise help courts to determine with accurately and efficiently where the truth lies. So that's the same argument as McHugh's first argument. Okay. All right. So he's also saying that Grant's case is a settled statement of common law in Australia. While a common law can be changed with social conditions or contemporary understandings of fundamental rights, that in itself is not a reason to change the present circumstances. So he's saying that basically he doesn't think that that's a sufficient reason. Changing society's views is enough. His argument is that the tendency of the common law has been to confine, not to expand the ambit of the privilege. Okay, so the majority's view is to expand the privilege, which is not what the case law had been doing. Common law had been trying to restrict it, whereas the judgment of the majority is actually trying to expand it. So I thought that was contrary to the common law. So there's all these sorts of, basically what I'm saying is there's all these reasons that Kirbys come up with and McHugh, which run the opposite direction to the majority. And this is a useful case because it shows you that, this is a difficult area of law. There are conflicting views, and not all the cases that we deal with are neat. You tend to get this false, I suspect the law students get a false impression as they go through. They're presented with, lots of cases. This is authority for that. Okay, what I'm trying to say to you is don't lose sight of the fact that some cases are hard cases and that you get conflicting views. And this case could have easily gone the other way because the majority was only 3, wasn't it? And you've got 2 going the opposite direction. If one of those 3 in the majority had changed their view, we would have had a different outcome. So that was the main reason for bringing up this case. Apart from the fact that it establishes the test, but it's also a hard case, and you can look at the various decisions. All right, then you're asked, the second part of the question, what are some of the factors which go to determine the question of competing public interest, so far as it relates to disclosure? So you can see there, all I've done is set out the waiver, abrogation by statute, improper or legal purposes. We can probably put in there as well the future, I might just add that actually, I think the future offences. I'll just add that there while I think of it. All right. So basically, those exceptions are really limiting the extent of disclosure. Well, they're not limiting. They're limiting the privilege against disclosing things. So you can see there, all I've done is set out the rationale and then the competing public interests question, which is what I raised earlier. So that's really, I think, what that's getting at. And the last little bit is how can we reconcile the importance of court having access to all information in order to do justice with the notion of legal professional privilege? So how do you balance those two things? You've seen how the High Court's balanced it. What would happen if we didn't have legal professional privilege? So if you couldn't rely on your lawyer not disclosing information you say to them and that not coming out in court, would people use lawyers?
No.
There'd be a risk that a lot of people wouldn't use lawyers. And where we'd end up would be a system where we would have everybody being a self-litigant. If anybody's ever been in a courtroom where you've got a self-litigant involved, the whole process grinds to a halt. It takes that much longer to do anything. And they don't have the legal skill to interpret the cases and the legislation and mount the arguments. Some people will, but the majority of them don't. So the whole system, the justice system, would grind to a halt if we didn't have legal professional privilege. And that's really the reason why that's a dominant public interest. Because if you took that away, you end up with a situation where the whole system breaks down. I don't know if there's any other points anybody can think of in relation to that, but that seemed to me to be the reason why the privilege is preferred over the other public interest of reaching justice. And that's the other interesting thing. And they're not courts of justice; they're courts of law. So what that means, I don't know if I ever mentioned this. So in a Court of Appeal case in Queensland once, when I was a judge's associate many years ago, this fellow had been convicted of one count of murder, and he was appealing against his conviction. And he was huge, this huge fellow, and he stood up in the Court of Appeal and he said, and he was representing himself. Someone said, is this a court of justice or is this a court of law? And the presiding judge says it's a court of law. So what that means is that you're restricted. The law restricts the information that can be presented in terms of making decisions. So it is possible that you can actually come to unjust decisions because you don't have access to the information which would lead you to make a just decision. So all the rules of evidence that restrict evidence going in, all of the privileges can have that effect, but it's thought that effect, it's more important to have legal representation and to have a smoothly running system than it is to have all the information there. So it's an interesting sort of dilemma, but that's how it's been resolved. So they're courts of law. Okay. All right. Any questions about any of that? No? All right. All right, the next one. You act for Fred, who has just lost custody of his children after a prolonged dispute with Mary, his former wife, in family court. Fred tells you in anger that he is going to take the children and go overseas and that he intends to get rid of Mary once and for all. The evidence presented in the custody hearing revealed that Fred has a potentially violent personality. What should you do? Okay. Well, how would you resolve that situation, do you think?
I put that under Rule 9 of the Australian Solicitors Conduct Rules. You're not allowed to disclose any confidential information, as we've already discussed. However, under Rule 9.2.4, you can disclose the information for the sole purpose of avoiding the probable commission of a serious offence. So I put down that what Fred is threatened to do is a serious offence and therefore will be allowed.
Okay, that's right. And the equivalent rules for the barristers are in 1881. So that's right. So if you come down here, the solicitor discloses information for the purpose of preventing imminent serious physical harm to the client or to another person. So that's the risk in relation to Mary. But what about breach of the court order? What do you think? See, there's several things going on here, isn't there? There's the risk to Mary, because he's threatening to get rid of her once and for all. But he's also threatening to take the children and go overseas. So he's then in breach of the family court order. So clearly we've got the result for Mary's situation. But what about the breach of the court order? What's the solution for that? We'll have a look at those. We'll go down to solicitors' rules. Have a look at those solicitors' rules again. So there they are. Is there anything there that says that the solicitor has to disclose or say anything to anybody about breach of the court order? Or is that confidential? So let's work our way through the rule. So look at 9.1. A solicitor must not disclose any information which is confidential. Well, it's clearly confidential information. It's been said in the context of, getting legal advice and in terms acquired by solicitor during the client's engagement. Okay, so they're clearly a solicitor. So they can't basically say anything except as permitted by 9.2. Now let's look at 9.2. Does it fall in there? The solicitor may disclose. Note the word may, so it's discretionary. It's not mandatory. That's why I've highlighted in bold the word may. Watch out for words like may and shall or must. So may is discretionary, shall or must is mandatory. So solicitor may disclose confidential client information if the client expressly or impliedly authorises disclosure. Has that happened? No. The solicitor is permitted or is compelled by law to disclose. What about that? Is there any law which requires you to disclose that you think that the court order is going to be breached? I don't think so. The solicitor discloses the information in a confidential setting for the sole purpose of obtaining advice in relation to the solicitor's legal or ethical obligations. Possibly, but you wouldn't disclose that. That would have to be perhaps to senior law society sort of person. It wouldn't be to a court or the police or anybody. The solicitor discloses the information for the sole purpose of avoiding the probable commission of a serious criminal offence. What about that one?
That's the one I took it as, and I took the taking of the children more seriously than the threat against Mary.
Yeah, that's right. So it could potentially fall under 9.2.4. It's not 9.2.5 because there's no serious physical harm and there's nothing about insurers. So 9.2.4 is definitely a possibility. Okay. So what about the barristers one? Is there an equivalent there? Looking at rules 80 and 81. Okay, threatens the safety of any persons. Well, it's not that. Risk to any person's safety, advise the police. Can you see that the barristers' rules aren't as extensive, are they, as the solicitors' one? So is there a difference between the position of the barrister and the position of the solicitor? There is, isn't there? See, the barrister doesn't have that requirement, but the solicitor does. So you can see there, certainly as a barrister, you counsel your client against taking that course of action and alert them to the consequences of adopting that. But there's no specific rule requiring you to do something about it. And even the solicitor's one is still couched in the word may, so it's still discretionary. So it really comes down as to whether the solicitor feels that they want to exercise that discretion to take advantage of that rule to prevent this occurring. But there's not a mandatory obligation for a solicitor to do this. And for a barrister, there's no obligation at all. Okay, do you follow where I'm getting all that from and what the argument is? But that's essentially what you're looking at. So did you, I'm just curious, I haven't read them yet, but I'll probably have a look at them all tomorrow on the website, the actual answers you put there. Did you think they had to do it? That the solicitor was required to do this, or did you see that it was it had the discretion attached to it? What did you do, Luke?
I've basically done my own notes on this. I haven't really put them on the website, but no, I was aware of the discretion. Then again, I took it to mean that if he's, looking at taking the children, breaching the court order and kidnapping his children, essentially, and again, that was a little bit more serious than was probably a thinly veiled threat against Mary. Under Rule 9.2.4. Knowledge that the client intended to commit a crime, and under the Rule 81 and 9.2.5.
Yeah, okay, that's fine. So what about Lauren? What did you do on the website?
I put that the solicitor should be able to disclose the confidential information.
Yeah, well, that's right. I mean, they are entitled to do that, but they have a discretion. But you think that they should? Well, probably if it was me, I probably would, because it is, as Luke's pointed out, it is a more serious situation. Once the kids are out of the country, it becomes a lot more difficult to get them back. I don't know, Brendan, what did you do?
I just, my internet just dropped out. I just came back. What was the question?
Oh, sorry. Yeah, we're just looking at this last. Question. We're just wondering what you thought about the position of the solicitor. Do you think they had to disclose the situation of Fred taking, or threatening to take the children out of the country?
I would say yes under, what did I say? Maybe under 9.1.2. Sorry, 9.2.2.
2.2, compelled by law to disclose.
I guess he's not really compelled by law, though, is he?
No, it's more 9.2.4. See, it says there, discloses the information for the sole purpose of avoiding a probable commission of a serious criminal offence. Because if it's actually a criminal offence to remove children from a country in breach of a court order. So that's what you'd be looking at there. I suppose, Robert, are you still there? Yeah, Robert's still there. What did you do in relation to this? You just have to unmute your microphone. That's it.
Yeah, no, it's just discretionary, but they have the choice to notify the court of it.
That's right. All right. Well, look, I think out of the three questions, that one's probably the most straightforward. I mean, well, the second question wasn't hard. It just took a bit of time to read through the judgments. The first one was a bit more difficult. All right. Now, just a couple of words about the client interviewing exercise that's coming up. Now, I've sent out a revised list of groups after I took into account some further information as to who was in what group, and checked a few emails that I should have seen but didn't, and then also to deal with various weddings and other things that people had on. So we've ended up with the allocation of groups. What you should be doing at this point is making sure you're comfortable with Zoom. Have a bit of a practice. You can practice recording with Zoom yourself. So have a bit of a play around with that. Make sure you contact the other people in your group so that you can agree on a time that you're going to do your interviewing sessions. And the way it will work is essentially, I've broken, you saw that there's essentially 3 interviews and you've got certain roles in each one. So what I will do on the day, on the 12th I think it is, from memory, I will send out the facts for the people in those respective roles so that you can then read through them, and you shouldn't be disclosing any of those facts to anybody else. So particularly if you're the client, because you'll have more facts in the client situation. You'll also have situations where you'll have some facts which you will only reveal if the person interviewing you asks you the right questions. Okay, and that's part of the process is to see whether you're actually asking the right questions to get those additional facts. So you've got 3 of those exercises to do. The actual interviews themselves should only take 15 minutes, 20 minutes tops for each one. So you should be able to do all 3 within an hour. And then the idea is that in your role, when you're the role of an observer, just make sure that you actually record the client interview, because you'll then have a record on your computer. It'll be saved as an MP4 file when you're finished. You can go back over that, and that'll help you write up your reflection as to what's happened. So in the actual question, I've given you a detailed sort of breakdown of the sorts of things to talk about in your reflection. But you'd also watch out for, you think whether people are asking the right types of questions, whether they discuss things like the client care rules, have they discussed the appropriate cost rules, that sort of stuff as well. Because typically these scenarios, I haven't written them yet, but I'll do them tomorrow on Saturday. But there'll be a fact situation, and there'll be essentially a client coming to see you to get some legal advice. And you need to think about what the elements of the offence or elements of a contract or tort or whatever it happens to be, to ask the right questions as to what additional information you might need from what the client initially tells you, and then they may have that subsequent information to tell you. Okay, you get the idea? So it's there's not really that much you can do in terms of studying for it. If you want to have a look at the couple of articles I put up on client interviewing for week 12, you want to have a quick read through those. That'll give you an idea of sorts of questions, open-ended, closed-ended questions, that sort of stuff that you can ask. But really, it's one of those things. It's meant to be an enjoyable exercise so that you get a little bit more experience in terms of client interviewing, and just see how you go. Have you got any questions about the exercise?
Yes. Do you listen to the recordings, or are we just getting marked on what we write and submit?
No, I'm not going to listen to the recordings. The recording is only for your benefit in preparing your reflection on it all. So I'm only going to look at the actual written document.
Okay.
You can share the recording with the other people in the team once the process is finished, so they can have a look back and just see how they performed. Because it's a bit different, actually doing it yourself and then seeing you doing it. It's a bit like if you film a moot and then you would go back and decompose it and just see how you actually performed. So that they can have a look at that film if you want to provide it to them. But mainly it's for the person who's writing the reflection, so that you've just got something to remind you what happened, rather than madly trying to take notes as it's going through. That's all. But I just thought it'd be better if you had a film of it. Okay. All right. Have you contacted your teams and got everything set up for it?
Yes, we're having a trial run on Sunday.
Okay. Oh, that's good. Give it a go and just make sure that your Zoom is working as well. It's pretty good. All right. Any other questions about anything at the moment? We all comfortable? Okay. All right. Well, we'll stop there. I've posted up these issues onto the website. I will have a look through all the answers tomorrow, and I'll write some comments on those answers on the discussion thread as well. I might, if I have time, I might have a look around for some more information or examples of approaches to client interviewing. There's plenty of manuals and things that other law schools have in relation to this available on the web if you want to have a look around. But you don't need to spend a heap of time studying for this. It's more about a practical exercise based on the knowledge you've accumulated of the law that you've done so far in your course, and applying it to a simulation, really. Okay. All right. Look, we'll call it quits there. Good to see you again. I'll see you again. See you again next week.
All right. See you then, Stephen.
Thanks.
Bye.
Bye.
Yeah.
Bye.